Et bonjour tout le monde. C'était juste une annonce pour dire que malheureusement, les interprètes ne sont pas disponibles, donc nous n'aurons pas une traduction de l'anglais, du français à l'anglais. Donc, nous nous excusons auprès de nos collègues anglophones qui souhaitaient suivre le programme en anglais. Et ensuite, juste pour dire que Maître Wilner Morin, qui devrait faire les propos et d'ouverture, malheureusement, a des petits soucis de connexion. Donc, nous allons commencer directement avec la discussion avec les panélistes. Et si le juge Morin arrive à se connecter avant la fin du programme, et donc il pourra faire son intervention à la fin. Et donc, nous commençons. Je suis Marie-Claude Jean-Baptiste et directrice de programme au Vance Center for International Justice. Et je suis heureuse de vous accueillir ce matin à ce webinaire sur l'état de droit en Haïti, défis et opportunités. Cette discussion s'inscrit dans le cadre d'une mission exploratoire conçue conjointement par l'International Legal Assistance Consortium, ILAC, et le Vance Center. Nous avions...
Maître Morin est connecté maintenant.
Je ne le vois pas. Un moment. Ah, d'accord, je vois. Catherine, I think he's connected as an attendee. Is there anything we can do about that?
Yes.
D'accord. Un moment, donc nous avons Maître Morin qui a pu se connecter, mais comme participant, pas comme panéliste. Donc, mes collègues à l'ILAC vont s'en charger, mais je vais quand même continuer avec l'introduction et en attendant que Maître Morin puisse nous rejoindre comme panéliste. Nous avions initialement prévu de mener la mission exploratoire en Haïti en 2019, mais ces plans ont dû être reportés à cause des multiples crises sécuritaires, politiques et enfin la crise sanitaire due à la pandémie de la COVID-19. Nous avons finalement mené la mission sous format virtuel au début de cette année en organisant une série d'interviews avec des acteurs clés du secteur de la justice en Haïti, de la société civile, des membres du gouvernement et la communauté internationale. Nous avons recueilli les conclusions de la mission ainsi que les recommandations avancées dans un rapport publié la semaine dernière. Ce rapport dont je vous parlais est disponible en français et en anglais sur les sites web de l'ILAC et du Vance Center. Il n'est pas un secret qu'Haïti fait face à des défis importants en matière d'état de droit, y compris un niveau de violence sans précédent, une crise constitutionnelle qui a paralysé la plupart de ses institutions et un système judiciaire qui peine à fonctionner. L'assassinat du président Jovenel Moïse en juillet dernier a mis à nu la gravité de la situation. En effet, la situation des droits de l'homme continue de détériorer vu que les autorités ne sont pas en mesure d'endiguer la violence et la montée rapide des gangs armés. Le système judiciaire n'est pas épargné. Des tribunaux ont dû fermer et à Port-au-Prince, l'activité judiciaire est pratiquement paralysée depuis près de 3 ans. Des juges travaillant sur des affaires politiquement sensibles font l'objet de menaces de mort et d'intimidation, ce qui empêche l'avancement de ces affaires. Malgré ce sombre tableau, de nombreux Haïtiens continuent de croire et d'œuvrer pour que le pays arrive à surmonter ces difficultés. Des progrès importants ont déjà été réalisés dans ce sens et plusieurs autres propositions intéressantes sont avancées. Les 10 années de travail pour réformer et moderniser le droit pénal du pays ont abouti à un nouveau code pénal et un nouveau code de procédure pénale. La création d'un système national d'assistance légale a également connu des évolutions positives. De leur côté, les avocats et les barreaux s'efforcent d'améliorer l'intégrité, la transparence et l'efficacité de la profession. Parallèlement, les professionnels du droit et de la justice proposent plusieurs réformes pour améliorer l'indépendance de la justice, notamment la réforme du Conseil supérieur du pouvoir judiciaire, le renforcement des mécanismes de surveillance des juges et des procureurs et une réforme juridique visant à clarifier le processus de nomination des juges afin de réduire les influences indues. L'objectif du webinaire de ce matin est d'explorer plus en profondeur non seulement les défis auxquels fait face le pays, en matière d'état de droit, mais aussi et surtout ces propositions ou cette solution haïtienne que beaucoup souhaitent. Nous sommes honorés d'accueillir pour cette discussion combien importante des professionnels du droit et de la justice en Haïti qui justement œuvrent à la réalisation de cette solution haïtienne dont on a tant parlé ces derniers temps. Nous allons donc commencer avec les propos d'ouverture du juge Wilner Morin. Nous continuerons ensuite avec les présentations des 4 panélistes. Nous laisserons quelques minutes à la fin pour répondre à vos questions. Vous pouvez écrire vos questions en anglais ou en français dans l'espace chat qui se trouve au bas de l'écran. Maître Jean-Wilner Morin est juge au tribunal de première instance de Port-au-Prince et l'actuel président de l'Association nationale des magistrats haïtiens. Juge spécialisé dans le traitement des dossiers contre le trafic de la drogue et le blanchiment des avoirs, le juge Morin a publié plusieurs articles sur l'état de la justice en Haïti et a fait de nombreuses propositions pour la réussite de la réforme judiciaire dans le pays. Il est aussi ancien secrétaire général de l'Association des journalistes haïtiens. Le juge Morin est licencié en droit et mémorant pour le grade de Master 2 en sciences de l'éducation. Il détient un diplôme en théologie et un diplôme en communication et journalisme. Il est également professeur de droit pénal dans plusieurs centres universitaires en Haïti. Juge Morin, vous avez la parole.
Bonjour, merci de m'avoir attendu. Vous comprendrez que cela est dû à cause des problèmes liés à la communication. Je salue d'abord l'ancien ministre de la Justice et de la Sécurité publique, et le président de la Fédération des barreaux d'Haïti, Madame la secrétaire du Bureau des Nations Unies en Haïti, Madame la juge d'instruction de la juridiction de Fort-Liberté, Madame la modératrice, Mesdames, Messieurs. Permettez-moi, à mon nom propre et au nom de la magistrature haïtienne, dès l'entame de cette prise de parole, que j'observe quelques secondes de silence en mémoire des victimes telluriques du 14 août dernier. Il faut bien reconnaître que ce n'est pas de gaieté de cœur que nous intervenons au colloque de ce matin. La situation étant ce qu'elle est en Haïti, nous sommes donc projetés au devant des choix difficiles. Tandis que nous assistons à la déchéance quasi totale des institutions démocratiques sur fond d'une crise politique sans précédent, la population haïtienne est prise en tenaille entre le déchaînement meurtrier des gangs et les manifestations des phénomènes naturels mettant à nu notre incapacité à produire du savoir utile, susceptible de gouverner ce beau pays et d'assurer au grand peuple haïtien un lendemain meilleur. Nous avons dû choisir entre non-taire ou non-parler. Notre choix est donc sans équivoque. C'est en ce sens que nous avons répondu favorablement à votre initiative de porter la parole de l'Association nationale des magistrats haïtiens en guise de propos d'ouverture à ce colloque autour de la thématique Haïti, État de droit en péril. Sans désemparer, disons d'emblée que la thématique en elle-même est controversée puisqu'elle suggère d'un point de vue sémantique qu'Haïti avait connu une période où gouvernants et gouvernés étaient soumis à la règle de droit et qu'à la suite de cette période de floraison, l'état de droit en Haïti, nous nous sommes retrouvés inexorablement quant à présent dans un déclin des institutions démocratiques. Certes, la situation actuelle porte à son paroxysme la déchéance d'institutions basiques représentant les 3 pouvoirs de l'État. Je voudrais parler de l'exécutif, le législatif et le judiciaire. Piliers de l'État de droit, mais ce n'est pas comme si, qu'au moment du fait de leur existence, ces institutions se portaient valablement garant de l'existence de l'État de droit dans notre pays. L'expérience des 35 dernières années post-dictature de l'ère des Duvaliers est là pour témoigner et la diagnostic de votre rapport sur l'état de droit en Haïti ne nous fait pas mentir. C'est clair, vous l'avez bien écrit, vous l'avez bien présenté. Cependant, ces considérations sémantiques n'enlèvent rien qu'à la pertinence de fond de votre diagnostic en lien à la situation dramatique de l'état de droit en Haïti, à la croisée de cette crise multiforme et multidimensionnelle, d'où l'importance de ce colloque. L'Association nationale des magistrats haïtiens, pour sa part, s'engage, comme vous l'avez déjà depuis sa création, dans la lutte pour un pouvoir judiciaire institutionnellement indépendant, efficace et efficient, assumant pleinement sa part de responsabilité dans la bataille pour l'établissement d'un véritable état de droit en Haïti. Nous nous réjouissons de constater qu'à bien des égards, votre rapport soit parvenu aux mêmes remarques et conclusions que nous avions dans le passé élaboré dans votre document de synthèse intitulé « Le pouvoir judiciaire, 10 problèmes, 10 solutions ». Présenté au programme de chaire des ordonnances de gouvernance le 11 décembre 2020 à l'Académie de formation et de perfectionnement des cadres, à la FEC, sans que nous n'ayons pu communiquer sur le sujet. Tout cela met en lumière l'importance et la pertinence de votre travail. Nous ne pouvons que le saluer et vous apporter notre maigre contribution. In fine, sur ce quoi nous devons mettre plus d'emphase à présent, c'est l'absence d'éthique chez les acteurs étatiques en général lorsqu'ils s'acquittent des charges de leurs fonctions. En effet, comment promouvoir l'éthique dans les institutions publiques en Haïti? Sur le fond de la crise que traverse Haïti en ce moment, relève davantage l'absence d'éthique dans la gouvernance publique. Les lois sont là, elles ont toujours existé, mais des hommes ont trouvé des subterfuges pour ne pas les appliquer. Les lois doivent être en adéquation à la réalité sociale et économique en Haïti. Mais à quoi servent-elles si des hommes s'évertuent ouvertement à ne pas les appliquer? J'aurais pu ajouter d'autres choses et faire d'autres commentaires par rapport à la situation où se trouve Haïti aujourd'hui dans cette crise où la justice n'existe pas. Malheureusement, je suis un acteur dans ce système. Juge au tribunal de première instance de Port-au-Prince, on se frotte à des situations où c'est la politique qui gouverne la politique, où la politique met l'état de droit en déroute, où la politique nomme les juges, où la politique révoque les juges, où la politique fait en sorte d'instrumentaliser les juges. La justice n'existe pas aujourd'hui en Haïti parce que nous n'avons pas de CSPJ, malgré les élections où toutes les institutions appelées à élire ou à désigner leurs représentants au niveau du Conseil supérieur du pouvoir judiciaire, cette institution qui devrait être forte, les représentants n'arrivent pas à trouver installation parce que la politique tient la justice en otage. J'aurais pu dire mieux, mais malheureusement, le temps qui m'est échu est vraiment compté. Je dois vous laisser en vous disant que Haïti, aujourd'hui, n'est pas gouverné. C'est ce qu'avait bien dit le bâtonnier d'Orval de regretter mémoire, jusqu'à présent, le dossier d'instruction de cet homme de loi se trouve dans l'impasse. Je vous laisse avec cette phrase de Montesquieu dans l'esprit des lois. Quand je vais dans un pays, je n'examine pas s'il y a de bonnes lois, mais si on exécute celles qui sont là, qui existent. Car il y a de bonnes lois partout, mais l'essentiel, c'est les exécuter. Merci et bon travail.
Merci, Juge Bourret. For our Anglophone colleagues, I have some good news. The interpreter is here. Hopefully you can see the globe-shaped button at the bottom of your screen. That should lead you to the English interpretation. Merci, Juge Bourret. C'est là une belle mise en contexte que vous nous avez faite, et non seulement des défis, mais aussi des opportunités concernant l'état de droit en Haïti. Nous allons donc continuer avec une discussion tout aussi intéressante avec les panélistes et que j'ai le plaisir de présenter. Margaret George est juge et juge d'instruction au tribunal de première instance de Fort-Liberté. Elle est secrétaire générale du chapitre haïtien de l'Association internationale des femmes juges et
of women judges and professor of the Faculty of Law, Economic Science, and a branch of the University of the State of Haiti. Josh is a graduate of law and specialized in financial control of the National School of Financial Administration. She is a graduate of the National School of the Magistracy of Port-de-France, the School of the Judiciary of Port-au-Prince. She has a master's degree in the science of education. Jacques Letton is president of the Federation of Bar Haiti and the president of the Bar of Haiti, founding member and president of the Administration Council of the Office of Human Rights in Haiti. She has had different posts in the judicial system of Haiti as a member of the Superior Council of the Judiciary and as a elected representative of the Assembly of the Bar from 2015 and as a magistrate of the prosecution office in the trial court of Port-au-Prince from 2002 until 2004. He's a graduate of the economic sciences and law. He has a master's degree in international law and human rights from the Catholic University and a graduate of the School of the Judiciary of Haiti. René Magloire is a lawyer. His area of expertise is the comparative criminal law and access to justice. He has served twice as a Minister of Justice and Public Security from 1995 to 1996 and from 2006 to 2008, and has been a member of the National Truth and Justice Commission. He is a member of the expert group of the National UN Office Against Drugs and Crime in terms of legal assistance. Mr. Magloire is a co-author of many draft law projects, including the right on the law on the justice, on the Superior Council of Magistracy, the law on the pertaining to the control and the repression of illicit trafficking of drugs, the law on the laundering of assets that comes from drugs, the law on legal assistance, the decree on the new penal code. And Pauline Le Carpentier is the Secretary General and founding member of the Office of Human Rights in Haiti, a position that she has been since 2015. Maître Le Carpentier operates in this field since 2006, holding many offices as a counsel jurist with a lawyering firm and as a representative of the organization of Avocats Sans Frontières Canada. She is a graduate of law from University Mendès France de Grenoble. Has also another degree, a master's degree in human sciences, in comparative research, in sociology and law from the School of Haute Études des Sciences Sociales. and a master's in the science of law, in the history of law and politics in Aix-Marseille III University. So without any delay, we shall start with the discussion. Maître Le Carpentier, in view of the situation that has been described during the mission, that is the closure of the tribunals, the violence and the insecurity, can we say that access to justice in Haiti is guaranteed? And what has been done for to improve access to justice, especially for the needy? Thank you for this invitation. Thank you for the question. We are going through a very specific timing. There are many judicial issues, but we are witnessing a progressive deterioration of the situation. Today, access to justice is not guaranteed in Haiti, and we are witnessing a double problem of impunity and arbitrary detention. When people commit crimes that are not sentenced, they are arrested and they are rarely judged, and therefore we are witnessing victims that do not obtain justice, and people who find themselves in big numbers in preventive extended detention and arrestation an arrest that is not followed by a judicial decision that would decide whether that persons are innocent or guilty, and that they have to stand trial or not. Thank you. Maître Le Temps, the establishment of the national system of legal assistance is a great breakthrough to improve access to justice, including the overcrowding in prisons. But the bars do not participate, even though they are key actors of the system. So what are the different factors that led to this position of the bars, and what has happened in the meantime? Thank you for giving me the floor to answer this question, a relevant question. We have to say from the outset that the adoption of the law on legal assistance that was in 2018 is a considerable breakthrough in the advance and the progress of the rule of law in Haiti. It makes it possible to facilitate access to justice for people who are economically poor. But this law that has been adopted to establish this balance between the needy and the people who are comfortable financially has been adopted by the ministry of the authorities of justice, because before setting up the council of the board of directors to define this policy for the implementation throughout the nation, this authority of the Ministry of Justice in cahoots with the national parquet wanted to make an interim justice in view of the measures regarding the appointment of directors or general directors within the Senate. They took so much time, and they wasted so much time, and because of this inertia on part of the executive power, the federation was compelled to denounce this slow action of the executive power and to pass many resolutions. So thanks to the insistence of the Federation of the Bar, there is a decree for a nomination in 2020. But despite the adoption of this decree and the publication of this nomination decree, it has not been implemented. We continue to fight at the level of the bar and the federation to force the authorities to comply with the terms of the law of 2018, and eventually there is a board of directors between brackets, between quotation marks, that has been set up without the Federation of the Haitian Bar, because the Ministry of Justice decided not to respect the rules of procedures for the establishment of this board of directors. And there is no meeting so far, no public meeting with the different members of the board to determine the implementation policy. We realize gradually that this measure is confiscated by the executive body, that is the Ministry of Justice in particular. And this explains the non-implementation of this process. They've recently announced the establishment they've taken measures without involving the members of the board of directors upstream and without involving the chairman of the bars that are really in charge of running these bar associations. This allows the executive power to violate the rules of transparency and independence that are supposed to guarantee the good and due progress of these institutions. There's some kind of complicity on part of some international institutions that are silent to this, if you like, hijacking of this process by the executive power. We remain open, of course. As previously mentioned, this is a guarantee for all citizens, especially the needy people. But unfortunately, nothing has been done. There's no measure, concrete measure to be considered so far at the level of the state for the Senate to work duly as a collegial body to provide this guarantee that we need so much. Indeed, this mechanism is necessary to guarantee access to justice. We hope that the discussions will continue between the Ministry of Justice and the Bar Association and the different stakeholders involved in the implementation of this project with Metroleto to come back to the security crisis and the justice. We know that justice, there's violence. There was the assassination of a chair of the bar, the operation, the progress of tribunals was disrupted. Well, in your opinion, what measures should be taken for the justice to be better secured? Since 3 or 4 years, security has reached its highest level, and in some cities and other areas of the country, especially the Port-au-Prince jurisdiction, we are deeply affected with the dysfunctioning of the different bodies of the justice, as you all know, where we have these courthouses in the capital city. The space was not pre-designed to hold the justice system. It's a space of the USAID that was graciously put at the disposal of the justice authorities after the earthquake that destroyed the infrastructure, including the infrastructure of the tribunals and courts. 2010, 2021, so it's 11 years that have gone by since the earthquake of 2010. The Justice Palace is there, but no measure has been taken to rebuild the Palace of Justice, which means that we shall continue to to administer justice in keeping with the conditions available. It has become a place of insecurity where criminals spread terror on a daily basis. The state authority is totally powerless and doing nothing, which means that for sometimes at the level of the lawyers corporation, we are working for the removal of the Court of Justice in order to enable the judicial apparatus to operate properly. The executive authorities really pretended to announce provisions and measures to reestablish security in the area, but so far what we notice is that the state is totally powerless. Recently, the Ministry of Justice, after several months and after many years of silence, announced they announced on the social networks, the Ministry of Justice announced the authorization for the relocation of the Justice Palace without taking the trouble of mentioning the new location and which public space has been designed to hold and host the justice authorities. This is to say that so far Haitian justice, even at the level of the highest jurisdiction in the country, is paralyzed. With regard to the question of insecurity, the authorities in Port-au-Prince had to give up the Palace of Justice in Haiti, in Port-au-Prince, for 2 years. The authorities of the trial court are still there. The bar of Port-au-Prince is still there, but for some time, the bar of the Port-au-Prince has given up. The authorities of the trial court are still there, but with the so many victims that are reaping the, if you like, the results. Just to answer the question, the state authorities are required to take the measures that would overcome this issue of public security, that would disrupt the progress of the justice system, and the justice system has to be supported by the police and to really arrest those thugs that are disrupting justice and spreading terror. And we have to add the necessity for the state authorities to rebuild the infrastructures of the Justice Palace of Port-au-Prince. It's not possible to wait for such a long time in order to start the work site for the reconstruction of the Palace of Justice. Mr. George, violence and insecurity in the country has not really discouraged judges. Judges who are working on high-profile political cases have been under threat, and some of them have been attacked. How do the judges react in front of these threats, and what measures are taken to ensure their protection in the long run? Indeed, we are witnessing a generalized state of terror. The spirit of law is disappearing, and along with that, the rule of law is dwindling down. The authority of judges is now disrupting. The social fabric is ripped off, and the magistrates and judges who are dealing with high-profile cases are often the subject of threats and are attacked. This is not a good image for the justice system. Unfortunately, the judges do not have any lever to react. Oftentimes, they resist or they have to really protect themselves. and in view of the attacks and the threats that are taking place. And there's a report of CSPG, and they have expressed the problems they are witnessing through their association of judges. They obtain the support and the solidarity of their colleagues and that of the association of judges. It's difficult to say, but we are in Haiti nowadays. We are encountering a serious justice issues. From day to day, the country is drowning in violence. It's an unprecedented violence. The judicial actors are not protected. Judges, lawyers, prosecutors are assassinated, kidnapped for ransom. They are attacking the justice system, and the judges cannot do their job. We cannot provide judges with armored vehicles, of course, but I think we have to teach judges how to protect themselves. When the judges are at the school of the judiciary for the initial training, we have to teach them self-defense techniques, how to use a firearm, how to disarm an assailant. The INA could include this in the training curriculum of the magistrates and the judges. And I think that the Ministry of Justice has to provide in its budget the construction of this building of justice in according with the standards for the trial courts, for the appeal courts, for the child care, for children having difficulties with the law. The judicial institutions have to be well designed, well furnished. The justice is sacred. Litigants cannot have faith in the justice system if they look at the constructions as they are in such appalling condition. So we have to broaden the spaces and expand the areas for the judges in the courts, and to allow a rapid access to the judges where the litigants enter. There has to be a different entrance for judges, different from that provided for the litigants. These are my recommendations, in fact. Indeed, it is important for the justice system to be housed in a decent location. That is, of course, important. In addition to the security crisis, the country has been through an unprecedented constitutional and political crisis in recent years. So we had an open conflict between the executive and the judiciary that triggered so many issues about the dependence of the judiciary and the principle of the separation of powers. In your opinion, are there any faults in the country system that would facilitate in the constitution? Are there reforms that could be considered in order to avoid these issues? The separation of powers is a principle of democracy that sovereign powers should not be within the hand of one person to avoid abuse. It's Montesquieu who said that the power has to stop power. The 1987 Constitution amended in Article 87, the citizens delegate the exercise of sovereignty to three powers: the legislative power, the executive power, and the judicial power. In Article 60, it precises that each power is independent from the other two in view of the attributions granted to each power. But between the constitutional spirit and reality, there's a sort of control of the executive power over the judiciary. This control and this grip has become very visible in recent years. The trade unions of judges and are aware of that, and they geared up to defend their rights. But there is no declared struggle, and the conflict has existed for some time. And this conflict exists. It could take a form of standoff between the different powers during salary claims due to the slowness and the refusal of the executive to renew the judge mandates. But when the executive power acts this way, it violates the judicial power and that of the judges in particular. After 30 years of the Constitution of 1987 that was amended in 2011, it's the first time that the nation heard of the head of the state that the judicial power would address the 50 judges, the corrupt judges. But it's the Constitution. In Article 675, the judges of the Upper Appellate Court are nominated by the President of the Republic based on the list provided by the Senate. Those judges of the Appeal Court are from the list provided by the Departmental Assembly. In reality, this article is respected just for the nomination of the judges of the Upper Appellate Court. The nomination of the other judges of the appellate courts and the trial courts that is made based on Article 8 of Decree of August 1995. This article is inconsistent with the wish of the 1987 Constitution, and that provided for the participation of the assembly, departmental and communal assemblies for the nomination of judges. But we have to admit that the country has done nothing to ensure the existence of these assemblies, and therefore the Constitution has never been implemented in its entirety. As a consequence, the breach is open for the executive to interfere with the judiciary, and the nomination of the judges is an opportunity to interfere with the judiciary. There has to be a balance between powers, and this balance when there is a well-defined distribution of powers and separation of powers. The executive, the power to investigate into judges was given by the law to the CPSPG. New amendments have to be provided to ensure separation between powers, to consider the nation priorities, and a reform has to be done in terms of the organization of justice. This reform has to take place to provide CPSG to have these attributions of managing the affairs of judges, because the judges have waited for a long time to see their mandate renewed, and the litigants are suffering in the meantime. Thank you. It's a big work site regarding the Constitution and the reforms. Mr. René Magloire, I've talked about the reform of the justice system that has been well received with regard to legal justice reform. One of the causes of the dysfunctioning of the justice, you have been at the process of the modernization that ended up last year with the publication of a new penal code and a new code of criminal proceedings. What can we expect from these new codes? What changes will be triggered, and how can we concretely, how can they concretely improve the justice system in Haiti? Thank you, Marie-Claude. Good morning, everyone. I'd like to thank ILAC and Vance Center for the kind invitation to take part in this webinar on the status of rule of law in Haiti, challenges and opportunities. This is indeed a great initiative for which I congratulate you very warmly. I'd like to add that it is a great pleasure to take part as we are dealing with topics that are so dear to me, because I have been working for more than 10 years, 7 days around the clock on these topics. I'd like to congratulate Judge Moret for the opening speech that I find very relevant and appropriate. I'd like to greet the other speakers for their valuable remarks. Allow me to say that the justice system that we have in Haiti is sick. The speakers that preceded me have already highlighted the weaknesses of the current justice system. Our system is really agonizing. I'd like to quickly speak about the dysfunctioning that we have noted in the system and that were at the core of our reflections, hence the penal reforms. I'm referring to the penal reforms. It's not really the reform of the code or the new penal code or code of procedures. The work that has been done is about a set of sectors and areas of expertise of the criminal justice. So that's why I speak about penal or criminal reform, because in the criminal code, we provided for the adoption of a set of follow-up laws in order to carry out the reform in a due fashion. The law on the reorganization and demoorganization of the clerical office, the law that was voted in 2018. What do we note in the system? The initial issue is the mismanagement in the judicial system. There's a total absence of managerial perspectives of the judicial system. The government's commissioners cannot say how many cases have been opened in the prosecution office. And therefore, this means it was possible for a minister of justice to have a criminal policy that is based on certain reality. Likewise, the head of the jurisdiction, the deans, find it difficult to control the investigating judges. Fortunately, with the GSP project in Haiti of USAID, we started to set up in the trial jurisdictions, we started to set up a computerized management of cases. In the report, you did not mention this project. In my opinion, this is an extraordinary breakthrough because the judges can, based from their offices, can follow the progress of the cases given to the investigating judges.
Défaillantes, les greffes fonctionnent comme de véritables boutiques.
There is no control over the clerks. This leads to delays and also corruption in the judicial system. As a second factor that we have identified. There's the dysfunctioning of the criminal chain. There's a lack of consultation regarding the different actors because the roles are badly defined in the current provisions. Lack of training, lack of equipment, and the forensic institute is not operating, and therefore the criminal chain is not working properly. The third factor that we pinpointed is about the procedures. The legal deadlines are not respected and periods at all levels, which triggered denial of justice. This denial of justice could trigger impunity because after 4 or 5 years, witnesses disappear or forget the facts. And in some cases, the elements could disappear, evidence could disappear from the dossier, from the files. The other dysfunctioning is the lack of access to justice. My colleague has already referred to that. The litigants cannot make it to the courts, and they cannot even have physical access because the nearest courts are kilometers away from their place of residence. There's a global problem of access to justice, and we add to this the barrier of language. And finally, I come to your question, the obsolescence of the codes. The codes date of 1926 and have not undergone any changes. Hence, the necessity to upgrade our penal code. And this is what we are now have been doing for 10 years, actually. Thank you, Maître Magloire. So to set up the new legislation, we have the decree was promulgated, but the political crisis did not allow a good preparation for the implementation. What are the necessary preparations of these codes, and how can the institutional crisis compound this process? There's in the absence of parliament, how can we improve the situation? The political crisis has delayed the implementation of the codes. For those who listen to us and who have not followed the progress of the work, in April 2007, the executive submitted 2 draft laws to the Parliament, one on the penal code and one on the code of criminal proceedings. I was present when the Senate, when the minister submitted the 2 draft bills, and the executive requested certain procedures. At the level of the Senate, the Justice Committee is presided by my friend, the Honorable Senator, who started to vote on the new criminal code in January 2020. At the end of the legislature, and the 2/3 votes are needed for the Senate. Finally, in June 2020, the executive decided to publish the draft bills by decree, and following these decrees, they have a deadline of 2 years. And now, both in the code, the penal code and the code of criminal proceedings, there is a need for a number of provisions for the implementation of these provisions. I've mentioned the list of laws that have to be adopted. There are 22 of implementation decrees. During these 2 years, we wanted to make some kind of, if you like, self-awareness raising for the public about these provisions and provide training for the different stakeholders regarding the innovations of these provisions and the training of the judges, the clerks, the bailiffs, the notaries, the judges, all the stakeholders involved in the reform. And we had to set up the necessary infrastructure. Because of the political crisis, we couldn't manage to implement these provisions.
Donc, qu'est-ce que va-t-il se passer en juin, le 24 juin 2022? Les textes vont quand même rentrer en application?
Et ça, c'est une question assez intéressante parce que les textes prévoient une date d'entrée en vigueur de 2 ans après la publication des textes dans le journal officiel. Donc, ça voudrait dire qu'à partir de juin 2022, les textes vont entrer en vigueur.
Texts will enter into force in June 2022, but the problem is that the training has not been made yet. You have texts which are not perfect. Some corrections should be brought to the text beforehand, before they enter into force, and we have questions.
Se pencher pour essayer de trouver une issue heureuse à cette question-là, parce que tout le monde est d'accord qu'il faut une réforme.
That a reform of the codes is required, and we should agree also on the means, on the appropriate means to implement them. Okay, thank you. You're right. I hope that a solution will be found before 2022, because this is important. Thank you, Mr. Magloire. We talked a lot about the criminal powers, and this needs reforms. Even CSPG is important in Haiti. It has been criticized, and you have a representative of the bar in this institution. What is the problem with the CSPG? Is it a problem of political will, or do we need deeper reforms? Mr. Leton? I'm sorry, yes, I was muted. I think that we need to precise that CSPG within law of 2017 is the regulatory body to reform or to impulse a process of deep reform of the justice sector. And it is the administrative area of the discipline of the judicial power. Various reasons could explain the criticisms to CSPG, which is a victim of the importance of its missions. I think that as an institution in charge of organizing the career of magistrates, CSPG should not be in charge of all the attributions given to it by law 2017, and up to now, then CSPG could not meet its functions, and the cleaning up of the judicial sector is not ensured by CSPG. The career of the magistrate is not totally ensured. The disciplinary powers is not taken in charge. Various factors could explain it. CSPG, as it is composed, is politically influenced by the executive power. When we look at its composition, the executive power should not intervene in the nomination of its members, and the entry of the executive power in the process, in the procedure of nomination of magistrates does not allow the guarantee of statutory independence of magistrates. Today, all opinions of CSPG on the nomination process of magistrates are not systematically followed by the executive power. Therefore, it is very easy for the executive power to enter the judicial affairs. And I could observe that CSPG is based on corporatist approaches. The composition of CSPG today, as magistrates are represented in majority, and very often we can see some judicial corporatism to protect magistrates, and there are complaints at the disciplinary level against them. CSPG then is faced with difficulties to give some hope, and which it was to establish with the establishment of these regulatory body. Various citizens today do not trust this body because the regulatory body does not meet its attributions according to the law. Okay, thank you, Mr. Le Temps. To go to another topic, the question of gender equality and position of women. We had various initiatives of the bars to understand the position of women in the area, what kind of actions could be taken to improve position of women in this area. In the Federation, we are based on the establishment of womenization of the profession of lawyers, but this is not easy. Various obstacles exist in front of women, and within the profession itself, which means that very rapidly women who have the statute of a lawyer abandon this profession, which is a noble one, to reorient themselves to other areas. And very recently, the Federation has tried with the support of one of its partners to establish, to achieve a study in order to understand the difficulties and probably to establish institutional mechanisms to facilitate the integration and the sustainability of women lawyers. And therefore, I think that we should think on the first hand to an institutional reform, which should go through the reform of the law, organizing the profession of lawyers to allow to keep more women within this profession of lawyers. Thank you, Mr. Le Temps. We should go to women judges. I don't know, as the bar did it, studies were carried out to understand the profession of women judges. According to your experience, what can you say according to position of women in the judicial area, and how can we improve this position? We are some 100 women occupying the function of judges in the judicial power at the moment. Can you hear me? Yes. And there's one woman in the Cassation Courts of the Republic, one in the Cassation Court, in the 5 courts of appeal. There's 6 women in Port-au-Prince, no judges in the Court of Appeal of l'Écaille, only 1 judge woman. So we have only 1 judge woman in for the courts of first instance. There are 3 courts of first instance, and with 50 judges, so we have only 5 women judges out of the 50 judges. In these courts of first instance, women judges are underrepresented in the judicial system. They represent only 12% at all levels. If this number improves, this will be thanks to our association, which and thanks to the intervention of one judge who wanted to have 50% of women judges and 50% of men judges. Regarding their conditions of work, they are the same. We are sharing the same insecurity as men, a problem of lack of space. Various judges are sharing the same office, which is a very small one. So we share also the same problem of wages. And at the level of CSPG, judges have some advantages regarding clerks. So the ministry should do the same for women. So we are sharing the same problems of inflation because wages, when we receive our wages, this is very limited. So we can say that working conditions should be improved if political powers establish gender policies to facilitate the access of women to this area, if they develop some ethic codes, because women are victims of sexist policies. So if women elect to be lawyers and judges, they are faced with this kind of violence, and we think that the solution should go through the balance between the new among the new courts. There are spaces where you have courts, new courts, so it is better to start with spaces where this is needed, and this should go through the strengthening of the independence of the judicial authority, and the solution should go through the strengthening of capacities of people, more training for judges, and personalized trainings. A judge should be trained. Certain training and certain specialization should be given to a judge who wants it. This should go also through better wages for all judges, and therefore an access to credit should be granted to women to acquire a car and to acquire a home in a area where there's some insecurity. These are my recommendations then.
Et toujours sur la question des femmes et
regarding women, we are mentioning that violence and gangs has terrible effects on women in the popular areas, and the rate of violence, gender-based violence, is very high. And can you describe the situation? What is the response of justice and police, for instance, how to improve the capacity of police and justice to find a solution to sexual violence? Thank you for your question. I hope that this the connection is good. We have a problem of sexual violence, but with the strengthening of gang violence in areas of in popular areas, we have the feeling that sexual violence is becoming a terror weapon. And various gangs are imposing strength and powers and controlling the territory and women, which is rather concerning. We could see sexual violence particularly terrible in the various areas. In the Saline mass murder, we could see victims of these mass murders who were exiled in other areas, and when they came back to their area, they were raped. The state is no longer controlling the individuals. There are some areas where police cannot enter, and there are other organizations of the authority which are not structures which will take into account the needs of victims. The role of justice is ambiguous, as you said, because there's a dysfunctioning of justice, and courts were not really open. Unfortunately, very few files could have some hearings, and this is a recurrent issue. We cannot give justice, and with symbolic sanctions and alerts. And since various years, some efforts have been made from the international community to establish some services to take into account sexual complaints, and some interesting things have been done, but there's some irregularity in the quality of service, and various women do not want to present their complaint because they know that will not be accompanied and will be faced to more violence. The case is difficult. Is even more difficult for the LGBT community because there's a sector working to impose women against violence against women. But for the case of violence related to sexual orientation, we could see bodies which rejected these people, these LGBT people, which are over discriminated. So this issue is particularly serious, and for which as defenders, we are accompanying various women. We don't know what to do because we're there to accompany them in the search for justice, but unfortunately we have to explain to them that this will be difficult. And one of the proposals which is important for some people is to imagine a fund for victims because victims are looking for economic repairs, and they abandon the trial to organize a discussion with the authors of crimes, but they do not respect their rights. So we should propose to the state to ensure to cover these victims, to ensure their protection and their rehabilitation and their accompanying the psychological, social and medical levels. So this is a proposal which should be studied in addition to offer spaces to accompany these women, and these spaces should be thought in order to welcome these women. And we have integrated these centers delivering medical services to propose to women other forms of accompanying to accompany them.
D'accord, merci. Ça touche sur une des questions du public. Je vais profiter.
This really affects the issue of regarding the public. Are there visible solutions to address this lack of trust in the judicial system among the public in Haiti? Unfortunately, for the time being, the situation is deteriorating. We are not in the trust building process. Actually, we have judicial authorities. As a lawyer, whenever I go to the tribunal, I'm afraid of dying. The entrance of the tribunal is a gathering point for the different gangs, and that is controlled by thugs, and therefore the possibility to go to the court and to appear in the court has become an issue, let alone security issues, and therefore we have to have a system that provides decent entrance, and there has to be an awareness raising for the stakeholders. And we have a female judge who is extremely sensitized regarding the judicial system. The system is not taking advantage of the resources available. There's work at different levels that needs to be done. And as I previously mentioned, we need to provide coaching to help the synergy with the different stakeholders to provide a better service to the litigants. Maître de Carpentier, a question regarding the public. Maître Magloire. The new codes have been published by decree outside the constitutional standards. What impact can this have on the legitimacy of the codes, and how can these codes be implemented by 2022? Shall we wait until 2022? Because the way the codes these codes have been published is that bad. Thank you for the question. At the beginning, the codes have been submitted to the Parliament, but unfortunately, as previously mentioned, the codes have not obtained the 2/3 of the two chambers of the Parliament. Now that the two codes have been published by decree, so outside the constitutional standards, we have to admit that because the process of the law has to go through the constitution. So the law is now promulgated by way of decree, and the entrance implementation date and enforcement date is mentioned. The measures that need to be taken, the reform is necessary. The dysfunctioning that I mentioned this morning will have consequences. The first consequence is an extended denial of justice, longer arrest of detainees, and under inhumane conditions, unacceptable conditions. The second biggest consequence of the current situation is the sustainability of impunity, or the continuation of impunity. Corruption is pervading our judicial system, and the final consequence, the deterioration of public trust in the judiciary. Justice is decried. Citizens no longer trust the judicial system, and they have a feeling of frustration and insecurity that they express. What we hope to achieve is that the criminal or penal reform would bring answers, or rather solutions, to the new problems that are really curtailing and disrupting our judicial system and straining our judicial system. Undoubtedly, the implementation, the effective enforcement of these provisions is likely to contribute to the improvement of the judicial system and to the re-establishment of the good image of our justice system. Thank you. Thank you, Maître Magloire. The last question. Just a few minutes for the panelists who wish to speak. The question, in view of the many years of support of international actors to the justice system in Haiti, how can we make better use of these projects for the Haitian people to ensure that international assistance for the judicial system would be in line with the expectations of the Haitian people and the Haitian administration? Of course, the floor is open for anyone wishing to really take the floor.
arrive en Haïti, qu'ils implémentent un projet.
Once we adopt a project, when these people leave the country, this project is abandoned. The Haitian people and the other players who are at the heart of the system, the judges, the CSPG folks, they have to, once they put money in the CSPG, they have to sustain the project. This has been done with JICA. When the justice, when we started this project, at the level of our tribunal, we have been very involved with the project. There was the CEMAC tribunal and the FOMETAC tribunal who are at the forefront of this project. Once this fund is gone, everything stopped because there was no way to pay for the internet. And therefore, with the GSSP, the project has restarted. When GSSP left, things stopped. GCAsh tool is very important for a court. With the issue regarding the procedures and at halt, we would know where these files are. Once we use the internet and once we send a file on internet, we will not lose this. We will be able to track this file. It's this example of chicage. We could continue and sustain these important projects that are very interesting. We as Haitian stakeholders, we have to continue following these projects. I take the example of GCAsh. It's not very costly to pay the internet, to have power available at the tribunals to ensure that procedures could go. The adoption of this project is feasible and possible. Maître Le Carpentier would like. It's an excellent question that is recurrent. It shows the importance of involving the civil society, not necessarily on a dynamic of a project, but in view of the structure of international assistance. It's a project-based structure that has a beginning and end with no sustainability. Therefore, we try through this dynamic of project, we have to be enrolled within an institutional logic. And we would like to ask our partners to really register within this logic to help us and to avoid any duplication. Sometimes there's a competition between donors. There has to be coordination among the actors and they have to take leadership. And it is up to us to indicate the vision and to join our partners who wish to coach us with all of their requirements, of course, which we understand, because it's the state also has an effort to exert, of course, in order to play its role, which is not happening at the level of the Senate, because the Senate is run by a council and run by the Ministry of Justice. Therefore, it's not a case of sustainability. Once the minister is changed, the minister is the direct one responsible for the judges of the prosecution, and this is who are one of the causes of the dysfunctioning. There's a role to be played by the stakeholders themselves, a state responsibility not to give up to any partisanship considerations and to take part. The Senate has to be an autonomous institution to guarantee independence and transparency of the process. And it has to really be involved with the other stakeholders, like the civil society. We've noticed many channels of dialogue with other stakeholders with the Senate, but very little feedback came from the other institutions to consolidate these initiatives. We need to reach out to the partners. We want to show them our vision, and we want to thank them for coaching us. Magloire, would you like to intervene? Yes, we can hear you. I just wanted, by the same token as the Judge George, and in line with what Mrs. Carpentier has said, the state at its highest level has to invest in the system, and unfortunately, in terms of the legal assistance, the judges, through the adoption of the law of 2018, these projects change, and once our international partners, once these projects are finished, these projects cease or disappear. And this is one of the reasons why we were pushed to work on this law for legal assistance in order to set up a sustainable structure. And that has to be supported by the Haitian state. We know that the Haitian state is now crippled by the financial and economic issues and cannot, for the time being, invest in the system. But I think we are on the right path in order to sum up. It is at the highest level of the state that this will has to play out. Thank you. Thank you, Maître Magloire. This is the end of today's program. I'd like to thank ILAC and our partners for the and I'd like to seize this opportunity to thank my colleague Webinaire and my colleagues from ILAC and ELI who are working hard for the success of this webinar. I'd like to thank Judge Omar Boulior, who has worked on the exploration mission. A great thanks to our panelists for this very important discussion that is just starting. We would like to maintain contact to see prospects of working together on the proposals that we discussed today. And those who would like to follow the work of ILAC on Haiti, and we incite you to visit our website where you can find the report in French and in English, and you can register to get our monthly bulletin. We recorded this webinar. It will be available on the website. Therefore, I'd like to thank all the participants, and I wish you a lovely day. I'd like to ask the panelists to remain online for a few seconds. And for the rest, thank you very much and see you very soon.